actually on the statute book.
My Lords, I rise also to speak on Amendments 32A and 52A. And just to follow on from the noble Baroness Ludford, I really appreciated that the noble Lord the Minister understood the concerns of the movers of these amendments. But as the noble Baroness Ludford pointed out, there have been reassurances given in this House over many debates, in fact, that there was nothing to worry about in terms of confusion in relation to sex and gender. And actually, we now have ascertained via the Supreme Court that there needed some clarity, and we've now got it. But I don't want to us to make the same mistake again. I did want to ask the noble Lord the Minister to clarify one thing he said in his opening remarks, which was that it would be overreach to ask the Secretary of State to declare biological sex as a material reality in all instances. I think that's what he said. But I'd like to point out that biological sex is a material reality in all instances. And despite the comments of the noble Lord Viscount Howsham in relation to his friend, I just wanted to clarify that it's not about passing or appearances. It's about biological material reality. And actually, in that instance, it's also the noble Lord, the Minister, started off to and called on us to have kindness. And of course, we should all have kindness all of the time, in every instance. But nobody here is trying to be unkind, but to clarify. And I like something that the noble Lord the Minister said in the past when he stated, we must have a simple version of the truth on this. There needs to be a way to verify consistently, and there needs to be rules. And I agree. It's not about kindness or unkindness. It's about clarification. I also think that, just an additional to what's already been argued, that this surely has to be about trust. And I can tell the House that quite a lot of people that I've spoken to are actually rather distrustful of digital ID of any sort. They're already cynical and anxious about what's going on with this data collection. I'm not raising that point other than to say that the one thing that you would want is that this particular measure is trustworthy in order to counter such worries. And yet, what we're talking about here is an officially sanctioned app that will allow the falsification of sex, even if that's not its intent. And that's to quote an article from Joan Smith in Unheard. It can be a form of self-ID that appears to be endorsed by a government trust mark based on documents that could be based on gender identity rather than sex. A government trust mark ought to be trustworthy. It's supposed to guarantee that the data it contains is accurate, and that includes sex. I think that something important happened with the Supreme Court's clarification, but of course this is an ongoing discussion in terms of how it has implications on a wide range of public policy. I understand that. But I do fear that there are times when people suggest that we should leave the Supreme Court up to some kind of relativistic mishmash. I mean, what's your reading of it? People keep saying to me. I don't think it's about the reading. It's a clarification of the law. And I do think that if this is inadvertently adds to that relativised muddle or an excuse for dismissing the Supreme Court, that would be an unintended consequence of what the government's doing. And I think it could be simply sorted out by the government themselves.